finishing up Unit 8. So we're gonna let me share my screen. I did create, if you will, a math problem last night because I couldn't find one that I like, so I just made my own. So we're going to do a little bit more math. We're going to do this one more commission math problem. We're going to talk about seller net, something called seller net, and then we're ready to move on. We're ready to head to Unit 8. So here's the problem. Hate to jump you in at 5:30 right at math, but you know, it is what it is. So take just a few minutes. Remember your commission map? Everybody remember your commission map where we have the listing side and the selling side, the split between the firms. And then the firm does an additional split between the firm and the agent. We don't go this far in this problem, but remember your map, remember your TBARs. Take a few minutes. When you have an answer, tell me in a private chat what that is. And then, of course, when you're done, give you a few minutes. And then when you're done, we'll go over it. Give you about 30 more seconds, then we're going to talk about this. And if you're just joining us, welcome. Tell me you're here in the chat. Okay. So let's see what we got with this one. Julie's real estate shop is listing a property for sale with an agreement from the seller to pay 6% of the sales price. Listing firm agrees to compensate the selling firm with 40% of the total sales price. How much will Julie's real estate shop collect on the transaction if the home sells for $300,000? So with commission math, I like to start with my map. And at the top, we're going to start with sales price. Whoops, and commission, the big picture on top. And we're going to take that and we're going to split it between the side. The listing firm gets some and the selling firm gets some. So we'll put the listing firm over here. We'll put the selling firm over here. In this problem, that's as far as we have to go, right? We're not paying any agents apparently at Julie's real estate shop. I'm going to collect the money and I'm going to move on. That's how we roll. No. So we're going to take the split between the firm and the two sides. What's the word of mean in a word problem? The word of means multiply. I know multiply. Yep. I know reading word problems is tricky, and that's why we got to look for these keywords like of. So the listing firm is going to give the selling firm 40% of the total commission. 40% of the total commission. So the selling firm is getting 40%, which means the listing firm gets to keep 60% for themselves. Of the total commission, do I know the total commission? Not yet. So now I go back to the problem. What's the commission? 6% of the sales price. So to find the commission, I can use my TBAR. I know the sales price is $300,000. I know the commission is 6%. So if I take 300,000 times 6%, I get a total. I'm sorry?
I was just saying 6 times 3 is 18.
Yeah. So we're going to take 300,000 times 6 times 3 is 18, and we get a total commission of $18,000. That total commission is what we're going to do a 60-40 split. So now that we know the total commission, now to find out how much the listing firm is going to get, we're going to do 40% of the total commission. Total commission, 18,000. Listing firm gets 60%. Solving for my X on top. 60% times 18,000 means Julie's real estate shop is collecting 10,800. Questions? Obviously, in real life, this would go on to say how the firm splits the commission with the agent. So we would have this as another split, whatever that compensation plan is. Guys, I really do like the commission map. For me, it gives me a visual. It helps me see what we're doing with this money, which direction it's going, etc. Any questions on this?
So, Julie, I have a question. I messed up.
Yeah.
So, okay, what I did was I took that 6%, and instead of making the 60-40 divide, I did 3%, 3% split. So can you kind of clarify? Because I know 60 and 40 makes the total of 100. I'm not sure what I'm missing.
Because you're right, 60/40 does make 100. 100% is 6%. 6% of the sales price. So if we don't know the 6%, if we don't know what this is, then I don't know how to do that 60/40 split. So that's why first we had to find 6% of the sales price gave us 18,000. And now we take that extra step and split it 60/40.
Okay. Okay. So if we were to, okay, I'm gonna save it. I'm gonna just email you. Thank you.
Perfect. And Danielle, I appreciate you saying that. Guys, remember, I'm available. Email, text. I get it. You know, this math is tricky. I get it. And you just got to practice with it. You got to spend time with it. And never forget, I'm here. I'm here. So if I can help, pictures help me, screenshots help me. Showing me what you're stuck on helps me get you unstuck. So if you show me your work, I can usually look at that and help you get unstuck, but I can't help you if I don't know what you're struggling with. Remember too, I also offer one-on-one tutoring. So if you're really, really stuck, then you absolutely can reach out to me to schedule some time. That's right. It's 40-60% of what? Of the total commission. Remember what those words mean. So it's 40% of the total commission. What's the total commission? 6% of the sales price.
I see now. There's literally two multiplication problems there because, gotcha.
There's two ofs. Okay. There you go. The 60/40 have to equal the 1,800. So if you took, this is 10,800, 40% would be
$7,200.
Thank you, 7,200. So if we were going to show this, what's 7,200 plus 10,800? $18,000. A lot of it is learning how to read these dang math problems. How do we get good at reading math problems? How do we get good at the math? Practice, practice, practice. Practice, practice.
Julie, is a lot of these examples, are they on Learn Test Pass as well?
Oh yeah. Oh
Okay.
yeah. Yep. We're just about done in Unit 8. I'm going to show you all the places you got some extra practice. If you blow through that and you want more, let me know. I don't know how many real estate books down here. I could throw you some more too. Every time I go to a conference, everybody wants to put a book in my hand so I can consider their product, which is fine because now I get more stuff to help you guys.
Julie, I don't know if anyone else does this, but when I look at these problems, I look at these problems very selfishly. I don't care about
How much am I
else.
getting paid?
Yeah, exactly. How much am I going to? I don't care about anybody else.
That's right.
In this particular case, I'm Julie. I want to know what I'm putting in my pocket.
That's right. So really all we need the selling side for is to figure out how much is in it for me. Once the selling side shares that with me, I don't care about the selling side anymore, do I? Because I want to know what's going to go in Julie's pocket. Okay. All right. We got to move on. So sources, practice, I'll get to it in just a second. We have one more type of math to talk about in Unit 8. And the other type of math that we have to talk about in Unit 8 is seller net. When we're working with sellers, we need to help the sellers figure out how much they're going to get when they sell their home. Do you think that's a common question for sellers to ask? When you sell my house, like Darian just said, how much is in it for me? You sell my house, what's in it for me? There are also times where sellers may look at you and say, if I can't make X amount, I can't sell my home. So we almost have to reassure them that we can put X amount in their pocket. No joke. I had a seller once. The only response I could get from that man was, I don't care as long as I make X amount. Do you want to list it for this? I don't care as long as I get X amount. Do you want to accept or counter this offer? I don't care as long as I get X amount. You willing to buy a buyer home warranty? I don't care as long as I get X amount. I was like, I'm gonna need some kind of answer from you. The guy wasn't being difficult. The guy genuinely didn't care as long as at the end of the transaction, he wanted X amount. Do you think as a listing agent with that seller, I had a material fact on my hand? Did I not have a material fact on my hand? Big time, because he told me something that was important to him. It was really, really important to him that I got him X amount. So they're going to ask you, how much am I going to make, or can you get me X amount? So seller net is how much they're going to get. So when we talk about sellers, first off, we need to understand seller's closing costs. Seller typically pays commission, unless we're told otherwise. Seller pays excise tax. Remember, we talked about excise tax in Unit 5. The one thing we haven't talked about yet that we will when we get to Unit 21, the seller also pays the deed preparation fee. The seller pays the attorney to prepare the deed for settlement. It's still the seller's deed, so they get to pay to have it ready. So some of the seller's closing costs, I always say if you can remember your alphabet, you can remember commission, deed prep, and excise tax. Is everybody singing the alphabet song in your head right now? So they pay typically, unless you're told otherwise, unless you're told otherwise, the seller typically pays CDE. In addition to CDE, the seller's responsible for any unpaid mortgages, any unpaid liens, delinquent taxes, right? They have to pay all of that, any money they owe on the property. They have to pay all of that before they get paid. So they pay everybody off, they pay CDE, and then they get whatever's left. When it comes to, hang on just a second, I can't. We're gonna do like this for 1 second. I'll have to come back to my, when it comes to seller net and helping them figure out, I like to think about pie. Let's talk about pie. When I'm trying to determine out the seller's portion, how much from the sales is the seller going to get to pay their expenses, to pay CDE, to pay their liens, etc. If we think about pie, if the entire pie represents a sales price, the entire pie represents the sales price. Of the entire pie, the seller is going to give one very small piece of that pie to the agent, whatever the commission is. So we have the sales price. The seller gives away a piece of the pie for the commission. And then the rest of the pie is the seller's. Everybody with me? And the rest of that pie is for the sellers to pay D&E. They just paid commission when they gave away a piece of the pie. So they're going to pay deed prep and excise tax. And then they're going to have the rest of the pie to pay off their liens and outstanding mortgages and everything else that they own the property. So in just a second, when we look at our TBAR, we're getting ready to see something called seller rate. And seller rate is going to be 100% minus commission. So in this case, seller rate is going to be what? It's going to be 95%. They gave you 5%. They gave you a piece of their pie. And they have 95% to pay off their liens, pay off all their debt, pay the deed preparation fee, and pay their excise tax. So seller rate is what we're getting ready to put in a TBAR. And seller rate is the entire pie minus the small piece that they give for commission. Questions on this so far? Are we doing math problems for what sellers make? That's what we're getting to do right now. That's what we're working up towards. Okay, everybody good so far? So far, so good? Seller rate, 100% minus commission. Our TBAR when determining seller net looks like this. Sales price goes on the bottom left. Seller's rate, seller's percent, nah. Seller's rate, seller's percent. The number on top, we're going to add up all the seller's debt except commission. What is the deed preparation fee? What is the excise tax? What are their outstanding liens? What are their delinquent property taxes? What all do they have to owe? What all do they have to pay on the property in order to sell it? To their debt, we're going to add their net. The net is how much they want to walk away with. What amount is the check that they want to put in their pocket when this thing closes? So the number on top is all of their debts and expenses except commission, plus their net. How much do they want to walk away with? Everybody have this jotted down? Do I have any questions on what we're doing? Very good. Why don't you guys just take a few minutes with this, see what you can do with it based on the T-bar we just saw and our seller rate. You've got 30 more seconds. Okay. So property owner wishes to net 56,500 from the sale of her small building. Seller must pay off her existing mortgage of 115,000, has agreed to pay the listing firm a 7% commission. What is the minimum selling price required under these facts? And we're going to round just a little bit. This seller is looking at you saying, I want to sell my small building. And when it's all said and done, I want to walk away with $56,500. Can you sell my house and put building and put $56,500 in my pocket? Everybody understand what the seller's telling you? Everybody understand what the seller's saying to you? So if we look at our TBAR, remember with our TBAR, I like to start with where I want to end. By that, I mean, ask yourself first, what's the problem asking you? And in this case, I'm looking for what? I'm looking for the sales price. My X is the sales price. This is the number I need to identify. Now let's talk about seller rate. What's the seller's percent? Well, you have pie, and of that whole pie, they're giving away 7%. The seller is giving away a piece of their pie. So if we're talking about seller rate, we take 100% minus 7, which leaves us with 93%. So my seller rate is 93%. Any questions so far? Everybody good with how I got the 93%? So now we need to figure out the number on top. The number on top is what the seller wants to net, all their expenses that we know of. Obviously, deed prep isn't on here. Excise tax isn't on here. I can only work with what I got, right? Do what the problem tells you. So the problem tells me, so the number on top is all the seller's net and all of their seller's expenses. All of their expenses except commission. Commission was just figured out here when the seller gave you a piece of their pie. Okay, that's where commission is calculated. So the number that goes on top is their net plus their expenses. In this case, it's a mortgage. So the number that goes on top is going to be 171,500. I added their net and their expenses. As you start doing more of these, we're going to throw in more expenses. That fourth line on the T-bar means what? This line right here means what? Divide. So we take 171,500, divide it by 93%. I get a minimum sales price. I'm just going to say 409. 185, that might be something you were going, kind of how you went around. In order for the seller to walk away with $56,500, I have to sell their house for $184,409. Anything less than this means the seller is going to get less, because they always have to pay off that 115, right? They'll always have to pay off that mortgage. They have a listing agreement saying that they're going to pay me. So if we sell their house for less than 184,409, the seller's not going to net 56,500, meaning when the deed is recorded, the amount of the check made out to the seller is going to be less than 56,500. What happens if I sell their house for more than the 184,409? I got a happy seller now, don't I? Right? I sell their house for more than 184,409. The seller's getting a check for more than 56,500. The key to seller net, the key to understanding seller net is understanding the seller rate. Understanding that that 93% is the piece of the pie. So let me ask you this. Without doing any other research, without looking at anything else, do you think it would be wise to look at the seller and say, yeah, I could sell your property for 184,409, no problem? Probably not. Once I come to this number, the next thing I'm going to want to do is my comparative market analysis. The next thing I'm going to want to do is pull comps. We briefly mentioned that. I think it was last night. We'll get there in unit 17. If I pull comps, for example, and I get close comps in the neighborhood between 160,000 and 175,000, do you think I can sell that seller's house for 184,409? Not unless they have a phenomenal feature that sets them apart from everybody else. You guys see what I'm saying? So before you make promises of, yeah, I can sell your house for 184,409, we need to pull our comps and make sure that that number can support that. Make sure that we can get that. Let's see. So you're not taking 7% of 171,500. You're not figuring 7. The number on top does not include commission. The number on top, I'm going to go back for 1 second. The number on top are all of the seller's debts plus their net, all of their debts and expenses except commission. So we added up the net, we added up their debts. How did I get you paid? Because the seller gave you a piece of their pie. That's what the 93 is about. The 93% is about. Because think about what you just said. You said 171,000, 7% of 171,000. What does of mean again? Of means multiply. So if you're taking 7% of the 171.5, what you're taking 7% of is the seller's debits, the seller's net. But we're paid off of the sales price, aren't we? So how much, in this case, how much commission are you going to get? You're going to get the 184,409 times 7%, because commission is of the sales price. So now that we know the sales price, now we can calculate your commission. So commission doesn't go on top. We're not going to add it on top. And before I make any promises, I'm pulling comps. I'm making sure that the comps in the neighborhood can support the sales price, that sales price. If I can't, if those comps don't support it, I have a hard conversation with the seller. And I say, one thing I know about life is that numbers don't lie. And I just can't make the numbers do what we want the seller to want the numbers to do, right? So if the numbers, I mean, it's right there in black and white. Would I just say 160 to 175, something like that? Like, seller, there's no way I can do this. If they insist, that might be a listing I'll walk away from. Because I just don't feel in my heart of hearts I can do it for them. Okay. Unit 8. Key terms, page 187, very beginning of Unit 8. Key point review.
Julie, can we go over another one of those, problems real quick, please?
Can we stay after class and do it?
Okay,
I'll
that's
be
cool.
happy to stay after class and do it.
Okay.
Key point review, pages 243 and 247, student quiz, 248 to 251. I do think you guys get it better when you do it without me. So you got math on 250, 251. Of course, knowing the formula is 80% of the battle, right? Are you guys putting these formulas on index cards? Cool. Knowing the formula is 80% of the battle. Don't know the formula, you don't know what to do with these numbers. And then for Unit 8 math practice, we got concepts 242 to 243 math concepts. The math concepts is a mix of commission math and seller net. So you'll see both 242 to 243. Those 50 problems in the back of the book on 803 to 808, these are the numbers that relate to commission math and seller net. And then in just a second, I'll show you where practice is and learn test path.
Julie, you said specifically commission split math is 803 to 808.
No, there's 50 problems in the back of the book on these on these pages. And of those 50 problems, these are the numbers that relate to the math that we just did. Let's see, we're getting ready to get into Unit 9. Next week will be Unit 10. After we do Unit 10, then we're getting into 14. 14 and 15, units 14 and 15 are our financing units. And I'll talk about this again before we leave tonight so we can get ready for next week. Good news is we don't see math again until we get to our financing units. So we get a few units off of math, which means you guys get the weekend, better part of next week, to get caught up. We've seen math in Unit 3, we've seen math in Unit 4, now we see math in Unit 8. Financing, 14 and 15, it just makes sense. There's math and financing. So take these couple units, get caught up on your math, look ahead at the math in 14 and 15. And in Learn, Test, Pass, oh, thought I had it up. And Learn, Test, Pass in the Unit 8 material, I got a commission and a seller net math worksheet. Somebody asked earlier about figuring out seller net. How much is the seller going to make? We're going to touch on that a little bit in Unit 21. This more focuses on what do I have to sell the home for in order to get the seller X amount. So it's a good place. And again, you guys, if you want more practice, just let me know. I can throw something together for you real quick. Questions? For the most part, we're done with agency. We're going to see agency again in our license law and commission rule. Have you guys been reading the comments? Remember we talked about the comments. I think they start on page 707. 707 of your book in Appendix A. Please be reading those a little bit at a time. License law and commission rule is the last thing we talk about in this class. And most of that is in that section, but it's also a good refresher on Unit 7 and Unit 8. 707. Little bit at a time. Y'all want a Kahoot? Let's play a game. Y'all got your phones handy? This Kahoot, as you guys are getting ready, I am too. This Kahoot is on unit 7 and 8. This is our agency Kahoot. It's either got the app, you're going to the website, or in just a second, you have a QR code. If you're doing the app or the website, here's your game pin. If you're doing the QR code, and you put your name in. Kahoot me. Sleep. 15 more seconds to get in if you want to play. Remember, don't let your phone go to sleep. It's Kahoot 7 and 8. No math. I would never put math in Kahoot. Anybody in that wants to be in? We good? All right, let's Kahoot. Let's see what we got. Question number 1, a broker is permitted to represent both the buyer and the seller in the same transaction when ten seconds. Look at you guys. Can I tell you what this does to my heart? A broker is permitted to represent both the seller and the buyer in the same transaction when, what do we know about dual agency? If we know nothing else, we have to have informed written consent of both parties. So both parties have to be informed and they have to agree to dual agency. Good job, guys. Any questions on this one? So let's see who got it right the fastest. Tara got in fast, followed by Lex and Gracie. Tara and Sabrina. Question number 2. Which of the following is not a material fact? Six seconds. Polybutylene pipes that have never leaked. They're not a material fact until they leak, right? Up until then, they're not a material fact. Let's go back real quick, make sure we're good to page 143. 143. And we got that paragraph right under the bullet points there talking about some issues have been declared to be material facts, and one of those being polybutylene pipes that have leaked. The eminent widening of the road in front of the property, that would be a material fact related directly to the property. So remember we talked about the different categories, things related to the property, things related directly to the property, things about the party's ability to complete the transaction. Questions on this one? So see what just happened. Tara, Kahoot Me, Lex, Sabrina, and it's not Kebab. Kebab? We'll stick with Kebab. Manny is our highest climber, 13 places this round. Good job, Manny. Question number 3, which of the following is true? Ten seconds. Which is true? Your relationship with your firm is that of a general agent. The relationship that the broker has with the firm is that of a general agent. Why? Because you have some decision-making ability. You have some power to make a decision. The property manager and the owner's relationship is also that of a general agent because there is some ability to make decisions. Let's look at page 149. Keenan Kebab. Page 149, we talked about the classifications of agency. Universal's the unicorn with full power. General has some power. Special has 0 power. Questions on this one? So we got Kahoot Me up top, Kebab, Lex, Lily, Sabrina's on fire with 3 in a row this round. We're shaking it all up. Question number 4, working with real estate agent disclosure must be given. Ten seconds. Working with real estate agent disclosure must be given to consumers in real estate sales transactions. What's wrong with the blue one? Is it
All
initial
buyers.
contact? Is it initial contact? Or is it for substantial contact? That's when
For
we're notifying
substantial.
for substantial contact. So we're going to give it to all buyers, right? Because they're in a sales transaction. And that's the key to working with real estate. It's all sales. So it's all buyers, commercial, residential. What's wrong with it is initial contact. We do our real estate for substantial contact. Questions on this one? We'll switch. Kahoot Me. Kebab's on fire this time. Answer streak of 4. Sabrina, Lex, and our smiley face. Let's come up. Question number 5. A listing agreement may be terminated for any of the following reasons except. 10 seconds. Listing agreement can be terminated for any of the following reasons, except if the agent's license goes on inactive status. Why? Not the agent's listing. The agent's license goes on inactive status. The listing remains because it's the firm's listing. All these others will terminate. Let's see, that's in unit 7, but specifically when we talked about the listing agreement in unit 8, we looked at page. Getting there, 222 and 223. All the reasons an agency agreement, a listing agreement specifically, will terminate. Questions on this one? Bob's on fire up top. Sabrina, Kahoot me. Gracie came back up. Lily. And the provision in a listing agreement that may obligate the seller to pay a commission after the expiration date is ten seconds. Ugh. Let's look at page 218. The override clause, also known as the extender clause, also known as the protection period. This is that provision in our listing agreement. If X amount of days after the expiration date, buyer comes forward, brings an offer, I may still be entitled to a commission. The two caveats with that provision, I have to provide the seller with the names of the buyers. So it's not just if any buyer makes an offer, it's if these particular buyers make an offer. I know Mr. and Mrs. Jones are interested. So I provide those names. The second caveat is if the seller lists with a different firm, in which case I'm out because they have a current agency agreement with another firm. Override clause, also known as extender clause, also known as protection period. What questions do I have about this? $218. Let's see what that did. Bob stayed on top. Sabrina. Is it Louie? I did this wrong on the first day too. Where are you at? I can't find them. I really do want to get your names right.
Luis.
Luis, that's what I did on the first day, isn't it? I'll get it, Luis, before it's over, I promise. Here's another one. Ciari. Did I get that one?
E.
Sari.
No, Sarah E.
Sarah E.
Yeah.
Just like it's spelled. Got it. All right. Thank you. And then Kahoot me. Shanika's our highest climber this round. Last one. Let's end with a bang, shall we? All of the following are typical provisions of a listing agreement, except 10 seconds. Responsibility of the buyers. Are the buyers in a listing agreement? Listing agreements between who? The seller and the firm. Sales price is a very important provision of the listing agreement. So of these, what you're not going to find in a listing agreement is responsibilities of the buyers. Questions? Before we do the big reveal. Okay, y'all ready? Our podium winners. Third place is Kahootme. Good job. Second place, Lewis. Our first place is Kebab. Runners up are, oh, and I don't see it in my Kahoot bar, Gracie and Sabrina. All y'all get yourselves a candy bar. Candy bar budget has greatly improved since I went on Zoom. I got to tell you what. All right, guys, let's take a break. Let's put agency off to the side for a bit. Clear your minds. Take a break. When we come back, we're going to jump into contracts. back? Everybody get some dinner during break? Kind of. I grabbed me some Subway today. Any day I can get Subway is a good day. I really enjoy Subway. Good stuff. All right. So let's take a 10. I just got a new BFF. Where do you live? That's so funny. All right. Unit 9. Let's switch gears. We spent a lot of time talking about agency. There's a reason for that. Remember me mentioning something about 7, 8, 9, and 10 being heavily tested units. We spent a lot of time in 7 and 8. Please do not put it down until the day before your exam. Keep going back and reviewing it. Keep going back and refreshing yourself. Units 9 and 10, we're getting into contracts. 9 is our basic contract law. 10, we're going to look specifically at the offer to purchase and contract that we use here, the standard form that we use here in North Carolina. Please remember, we are not in law school. We're not here to be attorneys. We're in real estate school. With that being said, we still need to study basic contract law because we use contracts every single day. So we need to understand how they work. We need to understand how they're created. We need to understand how they're terminated because we're so involved in them. Unit 9 is our basic contract law. I'm here to tell you guys there's a lot of words you need to know. Unit 9 is a great candidate for flashcards, knowing the words. Guys, first year law students would spend an entire semester on basic contract law. We're getting ready to blow through it in about an hour and a half. So you understand what they go through in law school and what we're going through in real estate school. Everybody kind of see that difference? So we're getting the basics of it, understanding we're not going to be lawyers when we're done. So in Unit 9, we're going to discuss our basic contract law. We're going to talk about the essential elements of a valid contract. If the judge is trying to determine if this contract is valid or not, the judge is going to look for these essential elements. There's some contract concepts that we have to define. Again, a lot of vocab words, a lot of words to just know the meaning. So Unit 9 is our basic contract law. And the first thing we need to do before we do anything else is discuss what the heck a contract is. Don't write this down. This is in your book on page 254. Word for word, I have no shame here. Word for word, the second paragraph. Basic definition of a contract is a legally enforceable promise or set of promises between legally competent parties supported by legal consideration to do or refrain from doing a legal act that must be performed for which the law provides a remedy if a breach of promise occurs. Do we see a common theme in this definition? Do we kind of see a common theme here? It's for a legal purpose. It legally binds people together. It legally connects them. Here's the deal. We put contracts in writing to keep people honest. If we had a contract on a handshake, a verbal contract, it's all fine and dandy until somebody does something that they promised to do or not to do, right? Until they broke their promise, until they broke their verbal agreement. So the main reason why we have contracts in writing is to keep people honest, to keep people moving towards the direction that they promised to do when they legally entered into the contract to begin with. And any contract is going to have a remedy of breach. What happens if one party doesn't do what they promised to do? Oral contracts are not enforceable. How do you make a contract enforceable? Put it in writing. If you take a verbal agreement, if you take a handshake to a judge, the judge is not going to hear you. He's going to say, show me your contract. So we're going to put them in writing, make sure everybody does what they promised to do or not to do. Contracts are voluntary. You can't be forced into a legally binding contract. You enter into it voluntarily. It's an agreement between the parties. There's a promise. The parties got to be legally competent. They need to be viewed by the court of law as able, to legally make a binding decision. Contracts are supported by legal consideration. Consideration is just anything of value. There's no free promises. They have to be supported by something of value. Most of the time, consideration is going to be money. In our offer to purchase and contract, the consideration is the purchase price. But it could be anything. What do you consider valuable? Love and affection? That could be consideration. 5 goats? That could be consideration. Something of value. And legally binding contracts have to be for a legal act. Does that not make sense? You can't have a legally binding contract for an illegal act. So if my drug dealer shorted me this week on my stash, I couldn't take it to the judge, could I? It's got to be for a legal act. Let's define some words. Express contracts versus implied contracts. In an express agreement, the terms are clearly stated. Maybe in writing, maybe it's in oral. We said if it's oral, it's not enforceable. But with an express contract, the parties state their term, they show their efforts. All real estate contracts are express in writing. Implied contracts is an agreement, it's based on your actions. How you act does not create a contract. Picture this. Let's say tomorrow night you go out to dinner. You go to a restaurant, they sit you down, server comes over, takes your order, places your order in the kitchen, they prepare your food. When your food is ready, they bring it out to you, you eat, you pay, and then you leave. When you go to the restaurant and sit down and place your order, it's implied that you're going to pay for it. Does the server take your order and look at you and say, now you're going to pay for that, right? It's implied that, not unless you're going to dine and dash, don't dine and dash, but it's implied that when you place your order and you get your food, you're going to pay for it. That's an example of something that's implied. It's demonstrated by actions. And as we said, any transfer of real estate has to be in writing. So it's enforceable. Contracts are either unilateral or bilateral. Lateral in contract world means side, S-I-D-E. I'll come back to unilateral. Bilateral is what we see the majority of the time. It's a promise for a promise. There's 2 parties that have to perform. It's a 2-way street. Our agency agreements that we just looked at are bilateral contracts. The firm has duties and responsibilities to the seller has duties and responsibilities to the firm. A unilateral contract, there's only one promise. Only one party is under the obligation to perform. We have a unilateral contract in real estate. It's called our option contract. And we will see it at the end of Unit 10. Our offer to purchase and contract, our agency agreements, our bilateral contracts. Both parties have duties and responsibilities. An executed contract versus an executory contract. An executed contract is fulfilled. Everybody has done what they've promised to do. In real estate, we call this closing. The seller sells and the buyer buys. That's the gist of our contract. It's been executed. It's been fulfilled. An executory is a contract that's still in motion. In real estate, our executory contracts is our contract to closing process. Something still needs to be done. We can't record the new deed just yet because something still needs to be done. Have you guys figured out yet in real estate, we like for one word to have several different meanings? You may also refer or hear an executed contract may also mean that it's been signed. So an executed contract, two meanings, either it's been fulfilled or it's been signed. We use our context clues. Once the offer has been accepted by both parties and it's signed, it's been executed. We're in the executory process, contract to close. Once that deed is recorded, it's executed and that the promises have been fulfilled. Let's look at an example. A buyer and a seller have signed, i.e. executed, a purchase agreement, creating a legally binding contract. The closing took place 6 weeks later. Prior to closing, the contract was executory, meaning that its terms remained to be performed. With the completed real estate closing, the contract became executed, meaning the contract terms have been fulfilled. Questions so far? So let's talk about validity of contracts. When we talk about validity of contracts, we're referring to whether or not they will stand up in a court of law. If the judge will determine if the contract is valid or not. If you guys will either take a picture or take just a few minutes and jot this down, we're going to talk about this in a second, but I want you guys to have it. Make sure picture might be good. If you're jotting it down really quick, these lines mean something. You guys see these lines here? So make sure you get those in your notes or on your picture. So the validity of contracts, make a note, top of your book, page 256, figure 9.1, nice little summary of what we're getting ready to talk about. You got that information there as well. The judge is either going to view the contracts as valid or void. The judge is either going to view the contracts as valid or void. If the contract is valid, it contains all of the essential elements. We're getting ready to talk about the essential elements of a valid contract. A valid contract can be enforceable. If a valid contract is enforceable, it will stand up in a court of law. It's binding, fully enforceable in a court of law. If you try to get out of a valid, an enforceable contract, the judge is going to look at it, say this is completely valid, it's completely enforceable. If you break it, you're in breach. Okay, it has all the essential elements and it will stand up in a court of law. A valid contract can become voidable. A valid contract can become voidable. It still contains all the essential elements. The contract itself can stand up in a court of law, but it can become voidable because one of the parties has the right to stand up in front of the judge and say, I don't have to carry through with the terms of this contract. The contract itself is enforceable, is valid, the contract itself is valid. But it can become voidable by one of the parties. So who's the party that can make it voidable? For example, in North Carolina, anybody under the age of 18 is considered a minor. A minor can enter into a contract, but you can't force a minor to carry through with the terms because they're not an adult. If somebody entered into the contract when they were under the influence, maybe prescription, maybe non-prescription, maybe alcohol, that person could make the contract voidable because they were under the influence when they entered into the contract. Contract itself is valid, nothing wrong with the contract. It becomes voidable because one party can stand in front of the judge and say, I don't have to carry through with the terms of this contract. We'll talk a little bit more about voidable in just a minute. A valid contract can also become unenforceable. Again, the contract is fine. It contains all the essential elements. But now either party can stand up in front of the judge and say, I don't have to carry through the terms of this. An example of an unenforceable is our handshake agreement. The judge cannot make anybody carry through with the terms of a handshake agreement, of an oral agreement. Either party. So with voidable, think one. With unenforceable, think either, both. Everyone think about that. That's what those lines mean. The valid contract is enforceable. The valid contract can become voidable. The valid contract can become unenforceable. How does it become voidable? One party goes to the judge and says, I don't have to carry through with the terms of this. How does it become unenforceable? Because we enter into it with a handshake. I do something you don't like. You take me to court. We stand in front of the judge. He said this and she said that. She promised me this. He promised me that. The judge says, show me your written contract. Well, we don't have one. The judge would call that unenforceable. You can't enforce an oral agreement. Here's the thing. A voidable contract and unenforceable contract are a valid contract. Either one of them could go on to closing. Either one of them could go on to execution unless one or both of the parties stand up in front of a judge. They only become voidable or unenforceable by the judge, not by the parties. So if nobody goes to the judge, we still got a valid contract that could be complete, that could be fulfilled. If the contract's not valid, it's void. Why is it void? Because it's missing one of these or more of the essential elements. With a void contract, in a sense, you never had a contract to begin with because you didn't have a valid contract to start. Again, we take it to the judge. The judge says one of these essential elements is missing. This contract is void. Again, if we don't take it to the judge, it could be fulfilled. Everybody hear what I'm saying? I can't make it avoidable. You can't make it void. That's up to the judge. For your exam, look with me, please, on page 256. Do you guys see that, for example, or example on page 256? The example for your exam that you're going to see of a void contract is when one of the parties has been declared legally incompetent by a court of law. Somebody that's been declared legally incompetent by a court of law does not have the mental capacity to enter into a valid contract. Thus, for your exam, if someone's been declared mentally incompetent by a court of law, that'll make the contract void. Everybody star that, highlight it, make a note of it. Questions so far? So let's see an example. Steve and Ted orally agree that Ted will sell his home to Steve for $175,000. Neither Ted can enforce the oral contract against Steve, nor Steve against Ted. Ted and Steve may voluntarily carry out their agreement and complete the sale, but if either refuse, the other doesn't have legal remedy. Why? Because it's unenforceable, it's oral. If either refuses, nothing we can do about it. So, what are these essential elements of a valid contract? You guys remember in Unit 5, we talked about the essential elements of a valid deed, and we talked about cake ingredients. There's certain ingredients you have to have cake, right? We talked about our essential elements of a deed. The judge is going to look at the essential elements to determine if he has a valid deed. Similar idea with contracts. These are the required ingredients for a valid contract. When a judge is trying to determine if the contract is valid or not, they're going to look for these essential elements. So first off, we have to have legally competent parties. They have to have the legal capacity, the mental capacity to enter into a contract. If a minor enters into a contract, the minor can make it voidable. Not the other party that's presumably an adult. The judge is going to look at the adult and say, why in the world did you enter into a contract with a minor? You should have known better. You're an adult. The minor is the one that can make the contract voidable. If somebody was drunk when they entered into the contract, they can make it voidable. Valid contract can become voidable. A valid contract has to have mutual assent. We're going to spend more time on this, trust me. Mutual consent is meeting of the minds. the two parties have to agree to enter into a contract together. And usually how that happens, one party makes an offer to the other party. That other party considers it. Maybe they counter offer it. Eventually, both parties agree, mutual assent, to enter into the contract together. We're going to talk more about mutual assent in just a bit. I have to have legality of object. Again, you cannot have a legal contract for an illegal purpose. In real estate, an example of something like this might be if the contract calls for immoral performance, maybe if the contract somehow shows discrimination against members of the protected classes. And then the problem topic of essential elements is that all valid contracts have to have some form of consideration. Again, there are no free promises. I'll pay you a purchase price. In exchange, you give me your property. The consideration is the purchase price. Consideration is something of legal value. If my parents were to give me their house, but just wake up and decide to give me their house, consideration might be love and affection. Love and affection is something of value. Question comes in, if they show they're drunk, do they have to show proof to make it voidable? That's going to be up to the judge, but somehow going to have to prove to the judge. Now, if they were out, y'all don't let a buyer or seller enter into a contract when they're sitting at the bar, right? Because now we got witnesses. What about this? What if your seller, you say, hey, we got an offer. Can I come over tonight after dinner to go over it with you? And the seller says, yeah, sure. And you go over after dinner and walk in the front door, the seller has their scotch in their hand. Hey, come on in. It's good to see you. Turn around, get in your car and tell them to call them in the morning, because you're not going to be able to have a conversation with them. You know that they were not in that capacity. Everybody good so far? Essential elements of a valid contract. The required cake ingredients. If I don't have these, our contract is void. Valid contracts also have to have reality of consent. So with reality of consent, there cannot be these things. There must be no duress. Duress is violence or threatening violence on a person to enter into the contract. You can't threaten a person. You can't threaten to harm a person to enter into a contract. Remember, contracts are voluntary. So if you're holding a weapon to somebody saying, sign this contract, they're not entering into it voluntarily. They're entering into it because they're scared. We cannot have any undue influence. Undue influence is the threat of emotional or mental harm. I think one of the most common examples of undue influence that comes up quite a bit is when the family hires somebody to care for their elderly parent, grandparent, and that caretaker takes advantage of the situation and has the elderly parent enter into a contract to sell their home. That was undue influence. They took advantage of that situation, of that elderly person. Misrepresentation and fraud. I can't have misrepresentation or fraud. Both of them are a lie. Misrepresentation is a lie. Fraud is a lie. The difference, what the judge is going to look for, is intent. For contract law, a misrepresentation is a lie when you thought it was true. Fraud is a lie when you knew it was a lie. Let's say, for example, I'm selling land and I'm selling 5 acres of land. And I genuinely believe it's 5 acres of land. I didn't have it surveyed when I bought it because I was trying to save some money. So I just relied on the fact that it was 5 acres. I went all this time that I owned it thinking it was 5 acres. I put it up for sale. Buyer makes an offer. That buyer had a better agent. Encouraged they get a survey done. And lo and behold, find out that that land is only 3 acres. We are both shocked. That's misrepresentation. Fraud, I have 3. I know darn well I have 3, and I try to sell it for 5. The difference is intent. Judge is going to look for intent. And then also there cannot be a mistake of fact. Mistake of fact could be some misgiven information, maybe about the contract itself, the property. Mistake of fact may, stress the word may, make the contract voidable. The rest of these, the first 4, will make the contract voidable. The party that felt threatened can make the contract voidable. The party that felt the emotional influence, or the party that was lied to, take it to a judge, make the contract voidable. Mistake of fact, it just kind of depends on that. Questions? Let's go back in your book to page 86. Remember our figure 5.1 on page 86, our offer or and our offer E, or our or and our E, I should say. So now that's where we are. We're going to look at the type of document. We're going to look at the offer. We're going to look at the counter offer. The offer or is the person giving the offer, the giver of the offer, the creator of the offer. The offeree is the person receiving the offer. It's way too easy to call it buyer and seller. Yes. So what are they going to call it? Offer or offeree. So the offer is a, how do I want to say this? It's an offering to enter into the contract. I'm presenting you with these terms. The offer or presents it to the offeree. I would prefer you guys to see the offer or as the giver or the giver of the offer, and the offeree is the receiver, R-E-C-E-I-V-E-R. Is that right? If not, you know what I mean. I would prefer you to refer to here giver and receivee than buyer and seller. Please do not think of offer or and offeree as buyer and seller. And here's why. The majority of the time, the buyer's making the offer to the seller. 98.5% of the times, the buyer's making the offer to the seller. but there have been cases, there are times that the seller makes an offer, the first offer to the buyer. So the offeror is the giver or the giver of the offer. The offeree is the receiver, receivee of the offer. Please don't hear buyer and seller. Offeror, offeree. Everybody with me? When anybody receives an offer, when the offeree receives an offer, the offeree always has three choices. They can accept it, they can reject it, or they can counter it. If they're accepting it, they're agreeing to all of the terms exactly the way they are. The slightest change, I don't care how small and insignificant it may seem, any change is not acceptance. If you're accepting an offer, you're agreeing to all the terms exactly the way they are. If you reject the offer's dead on the table, and both parties go about their business as if this offer never happened. I make you an offer to buy your house, you say, nope, we're done. It was that fast. Could I come back and present a different offer to you? Could I come back and present a new offer? Sure. But the offer I presented, dead, no coming back. If an offer is countered, also known as a counteroffer, a counteroffer is a rejection of the original offer. A counteroffer is a rejection of the original offer with a but. I'm good with all these terms, but the purchase price and the closing date. I reject your offer and I'm giving you a new offer of a new purchase price and a new closing date. With a counteroffer, the roles reverse. So you have the buyer on one side. As we said, the majority of the time, the buyer is the one making the offer to the seller. So the buyer's the offeror, they make the offer to the seller, the offeree. Everybody with me so far? The giver and the receivee. The seller now has three choices. They can either accept it and agree to all the terms exactly the way they are. They can reject it, which means it's dead on the table, or they can counter it. In a counter offer, the roles reverse. The seller is now making an offer to the buyer. I reject your offer. I'm good with all these terms, but the purchase price. So now the seller is countered. They've made a new offer to the buyer. The buyer's now the offeree. Now the buyer has three choices. They can accept it, reject it, or counter it. If they counter it, the roles reverse again. If they counter it, again and again. The only way to end a counter is to either accept it or reject it. We could counter till the end of time, or more likely until one of us accepts it or rejects it. There's not a limitations on how many times you can counter it. Hopefully, sellers start up here, right? They want a higher purchase price. Buyers start down here, right? Hopefully each counter gets us a little closer and a little closer together until together we're, together. Did I see a hand? Was that Lexi?
Yeah, so pretty much what you were saying is just negotiating back and forth, right? Until somebody accepts an offer.
Yeah, we're countering it. Yep. Negotiation is not the terms they're going to use on your test. A counter offer is a rejection. It's a rejection with a but, or however, whatever you like. We're going to spend more time on this. This is our mutual assent. This is our meeting of the minds. This is the two parties coming together and countering or negotiating, and hopefully, eventually agreeing to enter into a contract together. Questions? Why don't you guys remind me in the chat? Ooh, I'm going to go back a little bit. We talked about, well, how do I want to say this? What tells us that we have to record certain documents so that they're enforceable? What tells us that we have to record certain documents so that they are enforceable? So some of you are ahead of me. Back in Unit 5, we talked about the Connor Act. Connor Act in Unit 5 told us that we have to record documents. Why do we record documents? Why do we run the deed down to the register of deeds and put it on records? So that it's enforceable. So the Connor Act says there are documents that we have to record. As some of you told me, we also have something called the statute of frauds. Statute of frauds says that there's certain documents that have to be in writing. Why? So that they are enforceable. Connor says they have to be recorded. Statute of frauds say they have to be in writing. Connor says they have to be recorded. Statute of frauds says they have to be in writing. Why do we record? Why do we put them in writing? Both so that they are enforceable. So not only do we have Connor telling us that there's certain real estate documents that have to be recorded in order to be enforceable, now we have a new act called the statute of frauds telling us we have to put certain real estate documents in writing to be enforceable. The whole purpose of the statute of frauds is to prevent forgery, dishonest conduct, remember what happens if you have a verbal agreement. If you got verbal, you got nothing. If you got verbal, you got a story. You're standing in front of the judge going, he said this and she said that. Verbal will not stand up in a court of law. Statute of frauds says we have to put it in writing to be enforceable. Questions so far? Okay. So let's go ahead and take our break. We come back, we're going to talk more about basic contract law. Y'all ready to sign up for law school? Basic contract law. Okay, we're back. Any questions so far? Okay. Basic contract law, we have something called the parole evidence rule. What the parole evidence rule says that the written final word is going to override any previous oral negotiations. The final written word will prevail. For example, remember we talked about that refrigerator as personal property? And it's not just personal property. It's without a doubt the number one negotiated personal property item. So let's say, for example, the seller lists their property for sale, and they say in their advertisement, refrigerator to remain with acceptable offer. The buyer sees that the seller is willing to leave the fridge. They make an offer. They ask their agent, the seller's leaving the fridge, right? Buyer's agent calls listing agent and said, your guys are leaving their fridge, correct? Listing agent says, you betcha. Seller says, you betcha. Buyer says, great, I get a fridge. The refrigerator never makes it as an exception to personal property in the offer to purchase and contract. Is the seller under any obligation to leave the fridge? And according to the parole evidence rule, no. Because even though we all agreed on it, we advertised it, we agreed on it, we were all on board. The truth is that final agreement did not make it to the written contract. Both agents should have checked that. The buyer's agent should have had it in there. The listing agent should have made sure it was in there. It wasn't. Thus, the seller is under no obligation whatsoever to leave the refrigerator. Make sure everything your parties agree to wind up in the final written contract. That's the parole evidence rule. Questions on that? Okay. Talking about performance of a contract, there's some words we need to know. Time is of the essence is a drop dead date and time. Some performance has to be complete. Some act has to be complete by 5 p.m. on January 28th. Time is of the essence is a drop dead date and time. We have two time is of the essences in our contract. We'll see those next week when we look at our contract in Unit 10. If performance does not happen, the other party may have an out. Drop dead date and time. An assignment is a substitution of the parties. If you're assigning your duties and obligations to somebody else, you have transferred your rights. You have transferred your duties to somebody else. With an assignment, all the terms stay the same. The only thing that changes is the name of one of the parties. I think a good example of an assignment is when your lender sells your mortgage to another lender. They sell that lender with the terms, they assign it, I should say, to the new lender with all the terms exactly the same. Your payment stays the same, your interest rate stays the same, how much you owe and when it's due, all that changes, or all that stays the same. The only thing that changes is the name of one of the parties, and in that case, it is the lender. A novation is substitution of the contracts. You are creating a new contract to substitute it for the former one. Maybe you've renegotiated and you've come to new terms. You're under contract, you've all agreed, you've signed, but something happens and you decide to renegotiate and you come to new terms. The intent is to get rid of the old contract and replace it with a new one. I was so excited about 2 years ago, I experienced my first example of a novation. I said, oh, pre-licensing is going to love this. So I was the listing agent and I was listing the property for an investor. He bought it, he flipped it. I was listing it to sell it. I did not know this at the time. I know now. There's a rule with buyers that want an FHA loan that says an investor, if a buyer going FHA wants to purchase a property, the owner has to own it for 90 days before they can sell it. So FHA says the owner selling the property has to have owned the property for 90 days before they can sell it to the buyer. I didn't know this. My investor bought it, flipped it, went on the market. We went under contract on day 89. And the lender kicked it back because the lender said underwriting isn't going to accept this because it's not 90 days. So we sat still, we were patient. The next day, we did a novation. We signed a new contract, exact same terms, so the dates aligned, satisfied the lender, and everybody was happy. Day 89, are you kidding me? And I learned a lesson. Now I know. That was a novation. Tara, that's very common. Yep, especially because I think you said once you got a VA. Again, just an example. Contracts. Now, let me ask you guys this. Let's test your memory. I'm all about testing your memory tonight. Unit 5, we talked about zoning. We had a whole bunch of zoning words. And we talked about a zoning amendment. What did we say a zoning amendment was? What was an amendment? If you're amending the zoning, what are you doing? These question marks.
Julie, are you essentially asking for a change?
Yeah, that's, yep. Yep, we're getting in the chat too, but yep. So an amendment is a change. So if you're amending a contract, then you're changing an already existing agreement. You've come to terms, you've gone under contract. For whatever reason, you decide to round into round 2 of negotiations, you're renegotiating. You make changes. You have amended the already existing agreement. An amendment is a change. You just got excited. Compare an amendment to an addenda. We'll actually see an addenda. I can't remember if it's unit 9 or unit 10. When you see the word addenda or addendum, I want you to see the word add. An addenda adds to and becomes part of the offer to purchase and contract. An amended changes an already existing agreement. An addenda adds to and becomes part of. Remember in unit 20, we looked at the lead-based paint hazard addenda. We added that form to the offer to purchase and contract. So an addenda adds, an amendment changes. We're going to talk about, we have several addenda. we have a couple amendments, forms to look at. So as we get into the forms next week, contracts can be discharged. Kind of a fancy way of saying terminated. Contracts end, they can be discharged. Several reasons how contracts are discharged. The big thing I want you guys to see from this screen is agreement of the parties. The parties agreed to get into the contract together, so the parties can agree to get out of the contract. If they have mutual agreement, agreement of the parties, various forms of agreement, they can release each other. They can do a novation, they can substitute a contract. Maybe they, whatever, agree to different terms. They're substituting a new contract for an old contract. So that old contract would be the discharge, would be the terminated one. They could modify their agreement, agree to new terms. Accord and satisfaction is a partial agreement. Accord and satisfaction, one party accepts something less than what they agree to. For some reason, I can't perform as promised. I can't give you this, but instead I can give you this. I can't do this, but instead I can do that. The old school way of doing it was actually taking your paper contract and writing the word cancel across it. The parties could agree to just cancel the contract. So agreement of the parties, we agree to get into the contract together. We can agree to get out. Would example be, I can't fix this, but I can give you the money. That could be accord and satisfaction. You bet. Thank you, Tara. I can't fix this, but I'll give you the money to fix it yourself. As long as I accept that, that would be the accord and satisfaction. For whatever reason, you can't do as you fully promised. You can give me something less than, something partial than. Contracts can also discharge by full performance. Let's get this offer to purchase and contract to closing. In real estate, when we go to closing, when the seller sells and the buyer gets the new deed, it's full performance. Contracts can be discharged due to impossibility of performance. Once we go under contract, if we find out that the buyer can't get loan approval and they don't have the cash stuffed in their mattress, it's going to be impossible for them to perform. They got to have the money to fulfill their promise. As we said, mutual agreement. Operation of law. If the judge makes the contract voidable because a minor entered into it, the judge would discharge the contract. If the judge takes the property for any reason. And then another thing that could discharge a contract is if either party breaches. If either party does or doesn't do what they promised they would or would not do. There are consequences of breach. We'll talk about that in just 1 second. Those consequences of breach have to be spelled out in the contract. If you don't do what you promised me you said you would, how's that going to affect you? How's that going to impact you? Consequences of breach. So on page 261, there's some general rules for interpretation of contracts. This is how the judge is going to look at it. If we have, I don't want to go to the judge, but if we have to go to the judge is going to look for the parole evidence rule. They're going to make sure it's in writing. They're going to make sure we have the essential elements. The judge is going to interpret the contract as a whole. Like, they're not going to piecemeal it and be like, well, this provision's good, but this one's not. Either the contract's good or it's not. Any addenda that are attached are part of the contract. All the words in the contract are going to be interpreted for their ordinary meaning. Guys, in real estate, we have our own language. I mean, if we can make an acronym out of it, we're going to. But when I'm filling in the blanks of an offer to purchase and contract on behalf of a buyer, I can't use my jargon. I need to use language that the buyer understands. I need to use language that the seller understands. So don't use our industry jargon or all of our acronyms, because the judge is going to interpret them to how the buyer or seller understood them. They're going to interpret them for their ordinary meaning, not per the real estate agent. Remember, you're preparing these on behalf of somebody else. And any ambiguous terms or unclear language is going to be interpreted against the party that prepared it. So again, be clear, be precise. Don't leave anything up for interpretation or guess. When we're filling in these blanks, when we're completing these forms, make sure you use ordinary words, non-real estate language. So what happens if either party's in breach? Well, as we've been saying, there's remedies in the contract, and I got several different types of remedies. And first we have money damages. There are money damages for breach of contract. Compensatory damages. If you are suing somebody for compensatory damages, you are suing somebody for the money that you lost as a result of this contract. What money did I invest as a part of this contract? I'm not going above and beyond for pain and suffering. With compensatory damages, I should be able to produce invoices or receipts. I should be able to prove I paid for this. I wrote a check for that. You guys with me? I have documentation that I paid for this as a result of me being in this contract. You breached it. I'm out of money. I want you to make me whole. Compensatory damages, the injured party is being asked to be made whole again. If they're not willing, if the breaching party is not willing to sit down and write you a check, you sue them. You sue them for compensatory damages. I'm going to come back to liquidated damages in just one second. Let's go to consequential damages. Again, another form of money remedies. The injured party will probably have to sue the breaching party. These are special damages that occurred because of one party, the failure of one party to meet their contractual obligation. These are damages that go above and beyond the contract itself. They're not foreseeable. There, for example, is a provision in our offer to purchase and contract that says if the buyer or any of the buyer's agents, and in this case, we're referring to anybody that the buyer hires. So the broker, the home inspector, the appraiser. If anybody damages the property, the seller could sue the buyer for consequential damages. We couldn't foresee that. I didn't know the home inspector was going to damage the property, but it happened. the buyer acknowledges in the offer to purchase and contract that they will be liable for those damages. And if, again, if they don't willingly sit down and write out a check, the buyer can sue. Nope, the seller can sue. See why I want you guys using reputable home inspectors and not going to Google and finding one? Liquidated damages, we shouldn't have to sue unless, of course, somebody's being stubborn and won't do what they're supposed to. Liquidated damages are money damages that we agree to at the time that we enter into the contract. These are negotiable items of the contract. If you breach, you're going to give me $5,000. That $5,000 is a completely negotiable amount. It's part of our meeting of the minds. It's part of our mutual assent. So liquidated damages, if you breach, you owe me X amount. What's that X amount? We're going to agree to that when we enter into the contract. Liquidated damages in our offer to purchase and contract is the recourse for the seller in the event of buyer breach. So the seller knows if the buyer breaches, these will be my liquidated damages. This is how much I'm going to get. We will talk more about liquidated damages next week when we get into Unit 10. Questions on the money damages? I don't know why I keep bumping that tonight. Okay. Other contract remedies. There are money damages as contract remedies, but there are other contract remedies. Another contract remedy is specific performance. The injured party can sue the breaching party for specific performance, and upon being awarded specific performance, the judge can make the breaching party perform as promised. The judge can make the breaching party perform as promised. Where we see this is in the event of seller breach. If the seller breaches, the buyer can go after them for compensatory damages, possibly consequential damages, maybe, but they could also go after the seller for specific performance. And if the judge awards specific performance, they're making the seller sell. They're making the seller perform as promised. I don't like words like never or always. Those are pretty strong words. So I'm not going to say never, but it's going to be really, really, really rare when a seller can sue a buyer for specific performance. Usually what we see is the buyer suing the breaching seller to make them perform, to make them do as promised. And what was the seller's promise? To sell you the property. A recession to rescind the contract means you're taking it back. You're rescinding the contract. You're canceling it. You're taking it back. If you put down any deposits, you'll get your money back. Both parties go about their business as if it never happened. You rescind your contract. You take it back. Private chat time. Private chat. I'm all about testing your memory tonight. How many days does the buyer have to rescind a contract when purchasing a timeshare? How many days, Unit 2, how many days does the buyer have to rescind a contract when purchasing a timeshare? They take their money back. If they got put down any deposits. At least we remember the jazz hands, right? In a timeshare, the buyer has 5 days to rescind their contract. 5, 5, 5, 10, jazz hands, right? So the buyer has 5 days. I had 10 and 5 across the board. That's all right, we're getting there. So with the timeshare, the buyer has 5 days to rescind their contract. All right, another one, I'm on a roll. How many days does the buyer have to rescind their contract for a brand new condominium construction? A new construction condominium. You guys are ready for me on that one. How many days does the buyer have to rescind their contract? They take their contract back. If they put down any deposits, they get those back. And with a new construction condo, new construction only, not resale, the buyer has 7 days to rescind their contract. So that's a recession. You take your contract back. If you put down any deposits, you get them back. Both parties go about their business as if that contract never happened. It just poof, disappears. Magic act. Questions on contract remedies, money damages, specific performance, and recession. Not to confuse with the statute of frauds. There's also something in legalese called statute of limitations. Statute of limitations is just the amount of time that you have to bring a lawsuit against somebody. And that amount of time is different. It varies. The judge may have to determine if the statute of limitations runs out. Bottom line, what we need to know about the statute of limitations, if you're going to sue somebody, do it sooner rather than later. Because once that statute of limitations runs out, you've lost your right to sue. Statute of frauds, statute of limitations, Connor Act, flashcards. Good times. So, as we said at the beginning of this unit, we're not in law school. We're not here to be attorneys. We do need to understand how a contract works. So when it comes to contracts and when it comes to law, what's our responsibility? Well, let's start with what we can't do. I'm just a real estate agent. I'm not an attorney. I cannot practice law. And one act of practicing law is drafting legally binding contracts. This is why they provide us with pre-printed forms to use. The legal language is already drawn up. All I have to do is fill in the blank. Remember our agency agreements that we looked at? That whole legal document was already drafted up. I didn't prepare that. All I do is fill in the blanks. We cannot draft, delete, create verbiage in a contract on behalf of the parties to the contract. This is important. The broker cannot draft or add verbiage. The parties to the contract can. However, just because they can doesn't mean that they should. The parties to the contract, when they whip out their red pen and say they're going to make some changes, they don't understand the legal consequences of the changes that they are proposing to make. Are they adding verbiage? Are they trying to delete something? And when it comes to this, I always think of like the domino effect, like you hit one domino and they all fall down. We don't know by making this one change how it's going to affect the contract 3 pages down the road, right? That's what we don't know. That's for the job of an attorney. So just because they can doesn't mean that they should. When your buyers start threatening, I'm going to change this, we need to highly advise, highly recommend that they talk to their attorney. They can get themselves into a lot more legal trouble, having no idea, because they don't know the consequences, the legal consequences of those actions. Anytime you have any kind of change, it needs to be acknowledged by all parties. So once you're under contract, maybe we renegotiate the purchase price for whatever reason. I mean, I got a form to do this as well. One of the forms we'll discuss. But we can also cross through, write the new purchase price, and everybody initial and date. Everybody has to acknowledge and date this change. The form keeps it neater, keeps it cleaner. But if you want to go old school and do it on the paper itself, you can. Any change has to be dated and initialed by all of the parties, everybody on both sides. We're going to hear this several more times about how we're not attorneys, about how I can't draft. You guys start getting that in your mind. Guys, it starts like, and I think so many times we think we're helping, you know, but this is, remember, a lot of this class, we're teaching you what not to do. And a big, you know, part of what we're teaching is to stay in your lane. We can't act like an attorney unless you are. And if you are, please let me know. I'd love to have an attorney in pre-licensing. Would love to have an attorney in pre. I've yet to have one. I was under contract once. It was my buyer. The buyer's lender was based out of Texas. Now, I don't know how they do things in Texas, but evidently they do things differently in Texas than they do in North Carolina. And the lender called me, basically said, this provision doesn't work for us. Will you cross it out? No. All you got to do is cross it out. No. I sent the lender to my BIC. I don't know whatever happened to that. But can't you just? No, I just can't. Why? Because I am not an attorney. And I have a feeling what my BIC told that lender, but I wasn't there to to hear it firsthand myself. But it just kind of magically went away. Contract, let's see, page 263 is where you actually see addenda. I just want to talk about it sooner to compare the two. An amendment is a change, and addenda adds. So for those of you who like to see it in the book, there it is on 263. Auctions. Auctions are a totally different beast. Auction rules are different than everything else we talk about. Has anybody ever been to a real estate auction? A couple of you? Man, I want to go. I just need to go one day. We should all go. A little field trip. Let's do it. Auction sales. The seller hires the auctioneer to sell their property. So no, you haven't. To sell their property at an auction. So, you know, people may bid online. They may show up, you know, in the front yard and everybody stand there in the front yard and bid for the property. If the seller chooses to go with the auctioneer, their relationship, their agency agreement is with the auctioneer. There are two types of auctions. There are auctions with reserve. There are auctions without reserve. An auction with reserve, the seller reserves the right to stop the bidding at any time they are not satisfied with the results. With reserve means the seller has the right to say, you know what, this isn't working out for me, stop. An auction without reserve means the seller gets what they get. Whatever the highest bid is, whether they like it or not. When that gavel comes down and the auctioneer says sold, congratulations, we're under contract. That gavel coming down, that auctioneer saying sold, is binding the seller. The seller is now contractually obligated to sell their property to the buyer. The gavel comes down, the auctioneer says sold. What's the very next thing we're going to do? Get it in writing. But the seller is already bound. The auctioneer has that power, has that authority to speak on behalf, to bind the seller for that. Questions on that? I got a bonus for you guys, not found in Unit 9, but something we need to make sure we understand what the word is. So there's bonus material. And that bonus word is a contingency. A contingency says, I can't do this if I don't do that. Some examples of contingency say, I can't buy your house if I don't get loan approval. Or I can't buy your house until I sell mine. If I don't get loan approval, I don't have to buy your house. If I don't sell mine, I don't have to buy your house. I can't do B if I don't first do A. If I don't do A, B's not going to happen. That's a contingency. Contingencies in our contract do not exist unless the parties agree to create one. There are no automatic contingencies in our contract. The parties can agree to add one, but that would be an agreement of the parties. So if we find out after contract that the buyer's not going to get loan approval, they'll have to terminate. What are those consequences? We'll look at that in Unit 10 with our contract. If a buyer goes into a contract and still has a house to sell, and that house does not close, the buyer is still obligated to buy. They don't have an out. There are no contingencies unless the parties agree to include one. Y'all ready to sign up for law school? We just blew through a whole semester. Law School 101. Key terms are the important thing about Unit 9. Knowing those words. Key point review, 264, 265. Student quiz, 266 to 267. A lot of these things we said in Unit 9, we're going to see in Unit 10. We're going to kind of start incorporating into our discussions. Questions? All right. Quick breath. Unit 10. Unit 10 is our sales contracts and practices. One of the big highlights in Unit 10 is our offer to purchase and contract. Unit 10, we get to put buyers and sellers under contract. Yay. So in Unit 10, we're going to discuss and look at our offer to purchase and contract standard form 2T. We're going to talk about sales contract procedures. And then we're going to talk about some alternative land conveyance methods, some alternative ways to convey property. So let's meet our standard offer to purchase and contract form 2T. You don't need to know form 2T. You do need to know standard offer to purchase and contract. The North Carolina Association of Realtors, also known as NCAR, the North Carolina Association of Realtors is the state level of the National Association of Realtors. So you have NAR and then you have NCAR. NCAR, along with their legal teams, active members of the North Carolina Bar Association, have come together and created the forms for us to use. It is of my opinion that our standard offer to purchase and contract is the most important document that we use in real estate. Because the offer to purchase and contract is what legally binds the buyer and the seller together. Standard form 2T is the most common one that we use, but I need everybody to understand it's not the one that I have to use. It's the most common one. It's the one you're going to see most frequently. It's the one we're going to talk about next week. But it's not the only one I'm allowed to use. A lot of builders have their own contracts. Some firms may have their own contracts. Is everybody clear with that? It's the most common, but I'm not required to only use that one. The rules say I can use any offer to purchase and contract as long as it satisfies the standards of Rule A.0112. Don't worry about the rule number. Don't worry about the rules right now. We'll look at this rule when you come see me in post licensing. What you need to know right now is that there's a rule, and that rule says that there are certain provisions, there are certain things that must be included if any broker is going to use a contract other than standard form 2T. Questions? In our sales contract, big picture, big rule of thumb, we do not belong in the offer to purchase and contract. We are not parties to the contract. Who are the parties to the contract? The seller and the buyer. Agents don't get to go in the offer to purchase and contract. Specifically, the real estate commission says we can't have any mention of our commission. My commission doesn't go in the offer to purchase and contract. Here we go. I got only 10 more minutes. Remind me in the chat, where do I discuss my commission? If I don't discuss it in the contract, where do I discuss my commission? Where do we come to agreement to our commission? Yep. Yep. I'm getting ready to ban question marks in this class. No more question marks. Our commission is discussed in our agency agreements. So we have our listing agreement, we have our buyer's agency agreement. Commission is discussed in both. Our agency agreements are our employment contracts. And remember, at the latest, we have these things signed when we're ready to present the offer. An offer is not a contract. It's an offer. But we have our commission hashed out and signed by all parties before the contract happens. Everybody good with that? All of our commission bonuses, referrals, whatever, all that is figured out before we're under contract. Our commission. Would it surprise you guys? Would it surprise you if I told you there have been cases in the past, the commission has said there have been cases in the past where brokers try to slip themselves $500 bonus in the offer to purchase and contract? They see a blank and they're like, oh, I can get me a bonus, and slip it in there, party sign, not knowing what they're signing. And then they think they're entitled to this bonus because it's in the contract. Would that surprise? This has happened, y'all. So this is why we're standing here talking about it. The other thing that we cannot have specifically about brokers in the contract is any liability to disclaim a disclaimer of the broker. So I can't put a statement in there that says something like, I'm not liable for this. I'm not liable for mold, or I'm not liable for the square footage, right? I can't put anything in there to try to protect me. Again, big picture says agents don't belong in the offer to purchase and contract. That's between the buyer and the seller, the legally binding agreement between the buyer and the seller. We've entered into this new world in contract law, and that's the world of e-signatures. And because e-signatures apply to contract law, we have to have an act about it. So we've got the Uniform Electronic Transactions Act, UETA. The UETA is what addresses electronic commerce. So electronic documents, e-signatures. The UETA says, as long as you agree to use electronic signatures, your e-signature is binding. When you guys signed up for this class, Lane sent you an email, and within that email, she had you e-sign a document. She had you e-sign the contract for the school. And when you got the email from Lane, you clicked on the link, it took you into .loop, and you clicked on the terms and conditions, and you read every single word before you accepted. Every single word. Yes, y'all don't lie to me. Do we ever read terms and conditions when we're online? Do we ever click on that and read it? I'm just as guilty as everybody else. When you agree to the terms and conditions in .loop from Lane, you agreed to allow your e-signature be binding. That document you signed to get you into this class, you agreed, and UETA says once you agree that, you can't come back and say, that's an e-signature, that's not my real signature. You can't count that. And that's what the UETA says. They have to give you notice that you're using your electronic signature. And as long as you agree, which you did because you signed to be here, that signature is binding. Questions? So we touched on this earlier. I like ending here, so I know we could start here on Tuesday. So this meeting of those minds, the mutual assent, let's talk about this. There's this magic moment in time when it goes from being an offer to a contract. There's a very specific thing that has to happen. Actually, there's two very specific things that have to happen. So we're going to talk about this again for a second, and then we're going to start here on Tuesday. So that gives us time to get our brains caught up. And remember, I'm staying on after class to do a seller net problem. So if you want to hang on, I'll be done in a few minutes. So if you want to hang on after class, and actually I'll keep recording. I mean, I'm not doing it alone. Somebody's got to stay on with me, but I'll keep recording. So if you can't stay, you can catch it later. Fair enough? But if y'all leave, I ain't doing it. I'm not going to stand here and talk to myself any more than what I already do. Okay, so offer and acceptance. The offeror makes the offer to the offeree. The offeror is the giver of the offer. The offeree is the receivee of the offer. The offeree always has three choices. You want to rattle them off with me? Their three choices are to accept, reject, or counter. The offeree always has three choices. So let's draw our little, I call it the line because it's pretty appropriate, isn't it? Let's draw the line. You have the buyer, you have the seller. Let's have the buyer being the offeror, the seller being the offeree. Buyer makes an offer to seller. Seller has three choices. They can accept it, agree to all the terms exactly the way that they are. They can reject it, which would mean the offer is dead on the table. Nobody's out any money. Nobody's out of commitment. The only thing we're out of is a little bit of time. Or they can counter offer it. A counter offer is a rejection. It's a rejection with a but. What the seller is telling the buyer when they counter is that I'm good with all the terms that you presented me, except the purchase price. I'm good with everything else, just not the purchase price. When the seller counters, the roles reverse. The seller is now making a brand new offer to the buyer. The seller is the offeror, making the offer to the buyer who's the offeree. What are the buyer's three choices? They can accept it, reject it, or counter. We could counter again, we could counter again. With a counter offer, there is no going back. Once something is countered, you can't go back to those original terms. I could make a brand new offer with those original terms, but if you counter something, you can't wake up the next day and say, you know what, never mind, I'm good with your original offer. Because a counter offer is a rejection. A rejection kills it. So the offer's been rejected and a brand new offer has been made in its place. And with the counter offer, there is no going back. Everybody good so far? This is where we're going to end. This is where we're going to start on Tuesday. Okay. Questions, comments? I'm going to stop sharing just for 1 minute so we can tell everybody good night, and then I'll hang on with those of you that want to do another seller net problem. So Tuesday, maybe into Wednesday, we'll finish unit 10. Please make sure you look ahead at unit 10 this weekend. When we finish 10, then we move on to unit 14. Remember, I don't go in order of the book. I go in order of the syllabus. So if you're, please look ahead this weekend. Guys, people tend to struggle with the financing units. It's a new language. It's a new school of thought. It's math. So please, please, please look ahead at unit 14, possibly 15 this weekend. Let me know if I can answer any questions. I'm around all weekend. Don't hesitate to reach out to me. Otherwise, you guys have a good weekend. Hopefully we won't get snowed in tomorrow night. Y'all have a good weekend. We're going to hang out and do Stellar Net if you want. But otherwise, I'll see you guys on Tuesday. The Keenan's there too? Cool. Thank you. Good night. All right. We are still recording. I just feel the need to say that. So let's, let me pull up my little Word document. You guys got your book in front of you. Let's look at one of these in the book. Let's work one together in the book. So let's see. I'm on page 251. On page 251, why don't you guys take a few minutes and look at number 31. 251, number 31. And I'm getting ready to give you some things to consider. So there's your T-bar, there's your formula. Scratch that. I just actually read it. I'm so sorry. I'm so sorry. I was just seeing if you guys are paying attention, but bump. Okay. Sorry about that. Let's try number 32. Sorry about that.
Okay, I wasn't sure if you wanted us to do commercial compensation. Or...
I did not. I wanted you to do Stellar Net. So
Okay.
I saw a number, I got excited. Sorry about that.
That's okay.
You guys getting something? You want a few more minutes? You want to talk about it? Where you at?
Julie, did you want us to private message you?
If you want to, yeah, if you want to. I just want to make sure everybody's done before we talk about it. So that's one good way for me to know, but. You guys good? Okay. All right, so remember our formula, the formula for seller net, and there's two keys, if you will, to understanding seller net. First is understanding this number on top. The number on top, I'm going to take the seller net. The seller net is how much do they want to make? Is everybody good with that? When I sell my house and the deed changes hands, what's the check that I'm going to put in my pocket? What am I going to walk to the bank with? That's the seller net. In addition to the seller net, we need to look at all of their debits, all their expenses, whatever they have to pay to get out of this property, pay to transfer this title. All of their debits and expenses except commission. Commission does not get included in the number on top. Okay. So the number on top, well, first off, Julie, follow your own rules. First, you just read the problem, right? So number 32 says the seller needs $120,000 to pay off their mortgage loan and $1,000 for other closing costs. Plus, he would like to net $50,000 to use to purchase his next home. If the listing firm charges a 5% listing fee, what is the minimum sales price that will meet these requirements? So I've read the problem. I'm going to draw my T-bar. First thing I'm going to do is ask myself, what's the problem asking me? What am I solving for? And in this case, I want to know the sales price. My X is my sales price. So now the number on top is all the seller's debits, expenses, plus what do they want in net? So what do we know? They have to pay off a mortgage. They have $120,000 to pay off a mortgage. They have agreed to pay $1,000 in closing costs. Plus, they want to walk away with a check for $50,000 in their pocket. That's their net and their expenses. So the number that goes on top is $171,000. Wait, Julie, wait. When do I get paid? How does commission get figured into this? I'm like Darian earlier, you're thinking about yourself, right? Where's my money? My money is figured out when we look at seller rate. And when we talk about seller rate, that's when we're going to look at our pie. The pie represents the entire sales price. The seller selling the house, the sales price is theirs, right? So the entire pie of the entire sales price, the seller is going to give away a small piece of their pie to the agent. And in this case, they're giving them 5%. So if the seller is giving you 5% of their pie, how much do they have left? 95%. And that's the number that is our seller rate. To do seller net, put your seller hat on, right? I'm paying you, I'm paying my mortgage, I'm paying closing costs, and I'm netting $50,000. Now the question needs to know is what's the minimum sales price that I have to sell their house in order to net them $50,000? The T-bar, the back fourth line means divide. So we take 171,000, divide it by 90%, and I get a sales price of $180,000. Anything less than this means the seller's not going to get they're $50,000. If I sell their house for $179,999, the seller's going to get $49,999, right? Because they have to pay off the mortgage. They've agreed to pay the closing costs, and they've agreed to pay me. Anything more than $180,000, I got a happy seller, yes, because now they're going to get more than $50,000. The trick to seller net is their net and debits go on top, everything except commission, and the seller rate, figuring out how much of the pie is left once the seller pays you. So Tara sees, Tara, what you did earlier is the very common thing to do. So that's why I'm glad we worked that out. And I think with some practice, that'll. Questions? I see your mouth moving, but I can't hear you. And you're not showing that you're muted on my end.
What about now?
There you are. Hey.
Okay, hey. The seller rate, so that percent is always going to be 100% minus commission.
There you go. Yep.
Okay.
So whatever the commission the seller agrees to pay, that's the piece of pie they're giving away.
Okay.
So if I give you a piece of pie, I'm hungrier than you are as the seller, right? So I'm giving you a piece of the pie, but the rest of the pie is mine.
Okay. Okay.
So I
think
give you
that-
your
that
commission,
messed me up.
and then I get to keep the rest of it.
Okay. Thank you.
Sure.
Hey, Julie,
Yeah.
just to use some rough terms, right? Will they ever throw in, from a debt perspective, tax tag title or anything like that in the question?
You might get, that's a great question. You might get delinquent taxes. So if we're going to closing and the seller never paid 2021 taxes, that would be an expense. This year's taxes, we're going to prorate. Good night. We're going to prorate at closing. We'll talk more about that and prorating this year's taxes when we get to unit 21.
The long and short of it is all that's considered as debt that go against the seller, which would subtract from the final net.
That's right. So that would be a number that we would include
Right.
in this top. Yep. So, and God, we always do what the problem tells you, right? So like, for example, we know the seller pays excise tax, but the problem didn't specifically tell me to charge the seller excise tax. So don't get ahead of the problem. If the problem doesn't mention excise tax, then don't worry about excise tax. Just stick with what the problem tells you. Because we know how to calculate excise tax, right? We know just about enough now to be dangerous. But again, always stick with what the problem tells you. So unless the problem specifically says excise tax, pretend it doesn't exist. Is that good? Was that helpful? Walk through it. Pie. Okay. Study, study, study. Practice, practice, practice. Remember, I'm around all weekend if I can answer any questions.
Julie, I have one question. Do you want me to wait until you are done recording?
This sounds good. Let's see.